Please take your seats.
Good morning. Mr. Hardy.
Good morning.
Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana. The following four consolidated applications for special leave to appeal is called accordingly. CCJ application number 2 between John Solomon deceased by Faisal Mohammed versus Dawati deceased by Puran Chandika. CCJ application number 3 of 2019, Kisun versus Chandrawati Prasad. CCJ application number 4 of 2019 between Kisun versus Gauri. CCJ application number 5 of 2019 between Kisun versus S. Prasad deceased by Gauri. Can we have the appearances for the court, please? Thank you.
May it please your honors, my name is Sohan Punai. With me is Naresh Punai. Together we appear for the applicants' intended appellants.
Your Honor, I appear together with Mr. Narang Sapam and Mr. Ron Tilal for the response.
Thank you, Mr. Safi. Yes, gentlemen. We have, of course, read all the submissions, and we understand them as far as that is possible. My personal opinion is that the theme is how can we make things more complicated than necessary, but it is before us, and so we will hear it. Now, one practical question is that this is about the stay of execution, which was in the Court of Appeal, filed in the Court of Appeal. It is not about the appeal itself. Can you tell us something about the appeal itself, Mr. Punai? Is it still alive, or has that been dealt with?
Yes, Your Honors. The appeal, the substantive appeal to the Court of Appeal is still alive. Because, quite interesting, Your Honor, although the Court of Appeal ruled that it is not a valid appeal, it is not an appeal properly before them, they stopped short of dismissing the substantive appeal. Only the motion for the stay of execution was dismissed, as is evident in the written decision, Your Honor.
Curiosity, Counsel. When that took place, was the appeal called on, or is it that the motion was called on?
It was only the motion that was called on, Your Honor, not the appeal.
Okay.
So has
arguments were, however, heard on the appeal, sir, on whether it is properly before that court.
Has anything happened in that appeal?
No, Your Honor.
Because the the decision in the case before us seems to be based on a decision about whether or not there is an appeal before the Court of Appeal.
Yes, sir.
And
yes.
they have said no, there is no appeal before us because no leave was asked and no leave was given, and that should have been the case. That is what they said, basically.
Yes, sir.
Let me ask you this, Mr. Punai.
Yes, sir.
If this court, when this court hears this application, whichever way we decide, is it not still properly open to the applicants to go to the Court of Appeal and say, there are pending proceedings before the CCJ, but it is a fact that the substantive appeal has not yet been heard, and we are now requesting, we are requiring the hearing of our appeal, which as a matter of law and as a matter of right, we are entitled to.
Yes, sir, certainly. I believe that is a wise course to adopt, sir. Save and except, sir, our only concern in relation to that is that as we speak now, sir, there is an application before the tribunal in which the landlord is seeking to evict us. So the application presently for that stay is even more urgent, sir. I respectfully submit. So if we go back to the Court of Appeal, we would still respectfully seek an interim stay of that Rights Assessment Committee from proceeding is heard at the Court of Appeal, sir.
Sorry, you are seeking a stay from the Rights Assessment Committee?
The object of the application before the Court of Appeal, sir, was to preserve the status quo.
Yes.
In relation to the occupation of the applicant on the rights land until the appeal was heard.
Right, I have that clear.
The Court of Appeal refused that motion, sir,
Right.
and it is on that basis the refusal. Yes, sir, and that is why we refused this honorable court.
But sorry, I thought you were saying that there is now a further application, or I got that wrong?
Of the Rice Farmer Security of Tenure Act is a bit peculiar. There were two applications that were required to be made by the landlord. The first one was to ask the committee for leave to issue a notice to quit.
Yeah.
That was granted. The appeal in respect of that decision was filed to the full court and then to the Court of Appeal. Notice to quit is issued. The landlord is required by the legislation to go back to the committee for an order for possession pursuant to that notice to quit, sir. That is the peculiarity of the
And where is that
sir.
now?
So there were two applications.
No,
in
where is
order
that?
to
Where is that
me.
second application now?
That is presently before the rights. It is before the rights assessment committee, sir.
And what is the status of it, Mr. Punai?
So the committee has stayed the application for possession pending the outcome of the application before Your Honor.
Okay,
So then why do you need a stay from us?
Your Honor, the stay is necessary in order to preserve the status quo. If no stay is granted, then there is not stopping the Rights Assessment Committee from proceeding to make the order for possession pursuant to that notice to quit.
But then it seems to me, Mr. Punai, that until that order is made, you do not need to stay anything?
Under the Rice Farmer Security of Tenure Act, that second order is only a matter of course.
Right.
All the landlord has to show is that a notice to quit was issued by the Rights Assessment Committee, it was sent out, and used to deliver possession.
Perfectly
So there is
understood.
nothing else after the notice to quit was issued.
Perfectly understood, Mr. Punai, but until it is issued, then there is no execution possible. So even if it is something that you just write a letter to the registrar or the
The notice
committee,
to quit was issued.
huh? You're now saying that the order
The
evicting
notice to
them,
quit was issued, sir.
and have you applied for a stay of that?
No, sir. That is why we're before you, sir. I have applied for a stay of that before the Court of Appeal, and they have refused to entertain that application on its merits.
No,
So
no,
that's what we're
sorry.
before you.
Let's get back again. I thought you were telling me there was a second stage.
Yes, sir.
Mr. Punai, didn't you say that the committee has stayed the application for possession pending the outcome of these proceedings before this court?
Yes, sir. Yes, ma'am. That's
Could you
correct.
give me the date of that stay, please?
It was sometime last month, ma'am.
Last month?
Yes, ma'am.
June
I don't have my
2019?
diary. Yes, Your Honor.
Okay.
So June 2019, And this is a stay of the application for possession.
Yes, Your Honor.
And then the normal course would be, apart from the stay, there having been an application for possession, you say that as a matter of course, there would be an
Yes, sir.
order for possession.
That's correct, sir.
But until there is an order for possession, however much of a formality obtaining it is, until there is such an order, there can be no taking of possession, correct?
That's correct, Your Honor.
And that application for possession was filed in January of this year, is that correct?
It's in my record. Sir, please for 1 second, I'll get that, sir. Paragraph 38 of page 19 of 74 of the record of appeal, Your Honor, on the 20th of January 2019,
Yes.
that application was filed.
And that prompted you to apply for a stay.
Yes, yes, sir.
Okay, but you have a stay in the meantime within that, on the level of the Rice Assessment Committee?
Yes, sir.
Pending what this court is going to decide on the requested stay of execution.
That's correct, sir.
Okay.
Can I ask one other thing, Mr. Punai? Under the Rice Farmers Security of Tenure Act, can you appeal the order of possession?
Your Honor, Section 26 of the Rice Farmers Security of Tenure Act speaks about a landlord or any tenant who is dissatisfied with the decision of a rights assessment committee. That decision could be taken to include the order issuing the notice to quit or the order for possession, in my view, please, Your Honor.
So it could be appealed?
I would submit, Your Honor, that the order for possession, if one looks at the whole scheme of the Rice Farmers Security of Tenure Act, it is not appealable.
It's not appealable.
Because it is, no, please, Your Honor.
It's
It
not.
is the application.
You're saying it's not?
That's correct, Your Honor. I am respectfully submitting that the second order, which is the order for possession, is not appealable.
Section 26 of that act says any landlord or any tenant who is dissatisfied with a decision of an assessment committee under this act, other than where such decision is in this act stated to be final, may appeal therefrom to the High Court in the manner and subject to the conditions hereinafter provided. And the High Court is then the full court. And so, is it stated in this act that a decision for possession is final? In that case?
No, Your Honor.
It doesn't say that.
No, Your Honor, it doesn't say that.
So if it doesn't say that, then it would follow from Section 26 that it could be appealed.
Let me get Your Honor.
Mr. Punai, where in the Act is that statement of those decisions which are final? Could you assist us, please?
Your Honor, from my reading of the Act, I have not come across any of the provisions in which a decision is stated to be final in that Act. Any specific provision.
Okay, well, we'll have a look at that, but
Can I just ask Mr. Satram, do you agree with that?
Yes, Your Honor. We have no provision in the Act which says that any particular decision of the committee is final.
So you would agree with Mr. Punai then that the decision, an order for possession, a decision to give possession could be appealed to the full court?
It has to be, Your Honor, because the provision which confirms the right of appeal, 26.5 that Justice Witt referred, it seems wide enough to include all decisions of the committee.
Good. Thank you. Thank you, Mr. Sarkar.
Okay.
It's not a question that we really addressed our mind to, but it seems that
Thank you.
Okay, so that is that particular point. Now, the full court made a decision. You appealed to the full court. They gave a decision. They refused to go into the merits. They said you used the wrong procedure. And immediately, as I understand it, you asked the full court for leave to appeal to the Court of Appeal, which they refused. And then you filed a notice of appeal without asking for any leave directly to the Court of Appeal. That is correct?
That is correct, sir.
Okay. And now the single judge of the Court of Appeal and later on the full bench of the Court of Appeal, all quite complicated, they said, well, actually there's no appeal before us because you didn't ask for leave, and therefore alone we cannot go into this matter of a stay, and we dismiss it. That's also correct, huh?
Yes, sir, that's correct.
Okay. Now, one question is, suppose this particular issue would not occur, but suppose there was a proper appeal properly before the Court of Appeal. Could a Court of Appeal then decide to stay not the decision of the court which is now being appealed, but even a decision of the Rice Assessment Committee, which is further down the line? Is that a possibility? One would think that what a Court of Appeal could do is to stay the execution of the decision that is being appealed, which is the one of the full court, which of course cannot be stayed because that decision is simply that they will not go into the matter. Is that a possibility that you can ask for a stay at the level of the Court of Appeal of a decision not of the full court but of a committee that is further down the road? That's a question.
Yes, Your Honor. Our respectful submission is that it is a possibility. On the following grounds, Your Honor. The first one is that without a stay of execution, there is nothing to stop the landlord from taking possession of the land. In fact, in their affidavits on record, they have indicated that they are lawfully entitled to evict the applicant. So, if the Court of Appeal is not the proper forum to preserve the status quo, then we have no other forum to go to, because we can't go to the full court because there is nothing to stay at the level of the full court. It was a dismissal of the appeal. It was the only forum we could have gone to in order to preserve the status quo.
Mr. Punai, that's a dangerous argument you are propounding. If what you're saying is true, and I have no reason, sorry, not true, but accurate, yeah? I have no reason to decide one way or the other that there is not any avenue for a stay, to say that because there is not any other source of power to grant a stay of the committee's order, the Court of Appeal must inherently or implicitly possess the capacity to grant a stay, is, I think, novel. Does it not strike you as an extraordinary proposition?
Your Honor, the Court of Appeal, it is all respectful submission, have certain inherent powers available to them.
It has what, an
And
inherent
it is-
power?
Yes, please, Your Honor. In the face of a nugatory appeal, if successful, to preserve the status quo until that appeal is heard.
Well, I wonder why it is that something as inherent as that was thought appropriate to be made the subject matter of an expressly conferred power vis-à-vis orders of a court which are on appeal to them.
Pardon me, sir, I did not follow.
The Court of Appeal is given the power to stay execution of a court order
Yes, sir.
in the act itself. So it was
Yes, sir.
thought appropriate to give them that power in the act which creates the Court of Appeal because it seems that it would not otherwise exist.
That's correct, sir.
So I'm just saying that I find it remarkable that you should think that there is a power in the Court of Appeal to stay the order of, as Justice Witt indicated, a tribunal which is 2 times removed.
Your Honor, I understand fully Your Honor's point. But Your Honor, the flip side to that is what then does the applicant have to resort to in order to make sure that pending this appeal to the Court of Appeal, he is not evicted? And respectfully, Your Honor, it is on that basis that the applicant is submitting that the Court of Appeal can grant that stay of execution of the tribunal until the appeal is heard.
The answer to your question without giving legal advice is that the recourse of the applicant is to make an application to the High Court for a stay.
Very well, sir.
And I do not know, like I say, I'm not giving legal advice, I do not know the legislative framework sufficiently, but I mean, just off the top, it would seem that a judicial review application, for instance, that the decision of the tribunal was unreasonable, was very unreasonable, etc., would be some basis for granting a stay as an incident to a review application. But the difficulty that appellate tribunals face, whether at this level or at the level of the Court of Appeal, is with being asked to perform the function of a court at the first instance level. But anyway, just my remarks.
Mr. Punai, have you looked at the Court of Appeal rules or the true rule 16 and as to the powers of the single judge in light of the conversation with my colleague Justice Barrow? Here it indicates that for true rule 16, that with any cause or matter pending before the court, a single judge of the court may, upon application, make orders for, and C says, a stay of execution on any judgment appealed from, pending the determination of such appeal. And of course, that any order made by a single judge may be discharged or varied by the judges of that court. So I take it that means the full bench of the Court of Appeal.
Yes, Your Honor.
How does this affect that discussion?
Your Honor, If I may, Rule 16A.C. It says a stay of execution. 16.1c.
Yes.
A stay of execution on any judgment. Your Honor, and I think those are the operative words. On any judgment, it could be, Your Honor, a judgment of the full court, a judgment of a tribunal. It doesn't restrict judgment to any particular court.
Appealed from.
From, yes.
So you appealed from the judgment of the full court, and it is pending the determination of such the appeal. So that seems to restrict it to a judgment of the full court, which is of course not what you want. You want to go further down. So it's just a question that that is not clearly answered. Anyway, it is your opinion that we could go further down, that this would include the decision of the Rice Assessment Committee. That is what you...
Yes, Your Honor.
Yes.
Yes, Your Honor. I will respectfully submit that.
Okay. So now we get to the meat, so to speak, of the matter. Because there is a very strange thing, as we already indicated. The Court of Appeal refused the stay because they said there is no appeal before us, but at the same time the appeal is still there. So they have not taken that decision in the appeal itself that there is no appeal before them properly. And that is a somewhat awkward situation. One would have thought that if this comes before the Court of Appeal, that either you would have taken the initiative of the Court of Appeal itself to say let's take the two together, and then you would have a decision not just about a stay of execution, but a decision about whether the appeal has been properly brought before the Court of Appeal. But we do not have that now. You understand what I'm saying?
I quite clearly understand what you're saying, sir.
Yes. So that is a very confusing situation, to say the least. Wouldn't that be a normal practice? Or do I sound coming from Mars, that if you have a motion like a stay of execution like this, and the idea is, the argument is, oh, but this cannot be dealt with because the case itself is not, the appeal itself is not properly before us. Would that not normally lead to combining those two cases to have a determination right away? Is that?
Yes, sir, I would say that. I would say that would normally be the proper course to take, rather than keeping an appeal that the court has said is not valid, yet still extant.
So because now what you want us to decide is that there was an appeal properly before the Court of Appeal, while the Court of Appeal has not directly, at least, decided that. They say, well, we think so, and therefore we dismiss this motion. But they haven't said so in the appeal itself. Anyway, but you are arguing that the appeal is properly before the Court of Appeal. Can you succinctly tell us why that is so?
Yes, Your Honor. Well, before I get to Your Honor, may I just draw Your Honor's attention to the penultimate paragraph in the decision of the Court of Appeal.
Yeah.
If I may read, Your Honor. It says, the motions dated 13th of April 2018 is accordingly dismissed as there is no valid appeal before this court. So the Court of Appeal has made a pronouncement, but without striking the appeal out. They said that the appeal, there is no valid appeal before the court.
They have made the they have made the pronouncement, but not in the appeal. That's a little. That's awkward. But let's interpret it in this way, that they're saying, well, we foresee that when we deal with the appeal, that we are going to say that there is no appeal properly before us. And you don't agree with that?
No, Your Honor, I don't agree with that.
Okay, tell us what is wrong.
Your Honor, the Court of Appeal relied on Section 6(2)(d). It's concomitant Section 6(3) of the Court of Appeal Act. In ruling that the applicant's appeal is caught by the provisions of those subsections, being an appeal from a tribunal. However, Your Honor, our contention is that Section 6(2)(d) and Section 3 of the Code of Appeal Act does not apply to our appeal. Section 6(2)(d) and Section 6(3) contemplate a state of affairs where there is an appeal from that tribunal directly to the Court of Appeal, and not through the filtration process which is against the full court. Our appeal is not an appeal directly from the tribunal to the Court of Appeal. Our appeal is an appeal against the decision of the full court. Hence, our appeal is not covered by the provisions of 6(2)(d) and 6(3) of the Code of Appeal Act, Your Honors.
So how do we read this then? How is it caught? By what is it caught?
It is caught, Your Honor, our appeal is caught by Section 6(2) of the Code of Appeal Act, a decision against the full court.
You say 6(2) and then what? A, B, C, D?
But, Your Honor, it's 6(2),
6.
and it's not caught by the proviso of 6(2)(d). So it operates as an appeal as of right by virtue of Section 6, Section 2, which is an appeal against the full court, to the Court of Appeal.
But then 3 follows by saying, no appeal shall lie from an order referred to in subsection 2D, except, and then you get a few cases, and then in any case, except with the leave of the full court. And you applied for leave of the full court, or judge making the order, or of the Court of Appeal. So apparently you must have been of the opinion that leave is necessary because you asked the full court to give leave to appeal, which they refused. So wouldn't it make sense then to ask for leave to the Court of Appeal if when the full court didn't want to give it to you?
Your Honor, after I would have asked for leave of the full court to appeal against that decision, upon reading the Section 6 of the Code of Appeal Act, we have come to the interpretation that any appeal against the full court that is not caught by Section 6(2)(d) is appealable as of right. 6(2)(d) contemplates a state of affairs, as I've explained, Your Honor, where there is an appeal directly from that tribunal to the Court of Appeal. In this case, our appeal is not directly from the tribunal. It is against the decision of the full court.
Well, as I read it, it always speaks 6(2) speaks only about orders of the full court. And then it says where such order, that means the order of the full court, is A, B, C, D, an order upon appeal from another court, tribunal, body, or person. So, but it also says subject to as otherwise provided in this section. I must say it's put in a very complicated way, but that's what it is.
Your Honor, if I may, there is some help. There is some help to be gleaned from a decision that was laid over by my learned friend on the other side. The decision of the trademarks case. It's in the record of appeal, Your Honor, page 164 of 187.
Yes.
At page 172 of 187, Justice of Appeal Crane sought to rely on section 62D of the Code of Appeal Act upon any appeal from any other court, tribunal, body, or person. And to quote the Lord Justice of Appeal, in this case, on appeal from the Registrar of Trademarks, an appeal in this case can therefore be properly be made directly to us from the judge and not compulsorily via the full court as contended. My understanding of that decision, Your Honor, is that the Registrar of Trademarks being a tribunal, an appeal from the Registrar of the Trademarks is not filtered through the Court of Appeal, but it goes directly to the Court of Appeal pursuant to section 62D. In our case, Your Honor, we are not appealing the tribunal's decision. We are appealing the full court's decision. It may be upon appeal from the tribunal, and it is upon appeal from the tribunal. But the fact is, we are not appealing the tribunal's decision to the Court of Appeal.
Not
we
yet.
are appealing the full court's decision.
Yes. You are appealing the decision of the full court in order to be able to appeal the decision of the Rights Assessment Committee.
Yes, Your Honor, I concede that, Your Honor.
Yes.
But Your Honor, there's also one other point that I wish to emphasize, which in our submission lends support to our argument that...
Sorry, but before you go on, the counsel, and forgive me for disrupting you,
That's okay, sir.
the passage that you read from Justice of Appeal Crane, the last sentence in that paragraph says, an appeal in this case can therefore properly be made directly to us from the judge.
Yes, Your Honor. In that case, from the Registrar of Trademarks, an appeal was made to the Judge of the High Court.
Right.
And from the Judge of the High Court, the Justice of Appeal is saying that it can be made directly to the Court of Appeal.
From the judge.
From the judge and not through the full court.
Right. So what's your point here?
Your Honor,
It has
the
to
point
come.
is
It
that-
has to come through the court. Whether
in this case,
whether the single judge or whether the full court of the High Court.
in that case, it did not come from the full court, Your Honor. It came straight from the judge to the Court of Appeal.
Right. But it is not from the tribunal. It is from the judge.
Yes, Your Honor. It is from the judge.
Okay. I thought you were suggesting that it is that it can go straight to the Court of Appeal from the tribunal. No?
No, Your Honor, but in that decision, the Justice of Appeal has interpreted section 62D to mean that once it's from the tribunal, it can go straight to the Court of Appeal, even though it first went to the judge in the Judge of the High Court.
I didn't get that impression, but I may be wrong.
In that case, Your Honor, what the Court of Appeal has also underscored is that judge's order upon the appeal from the tribunal was not an order made in chambers. So it's not caught by six.
Forget about the chambers thing. The thing about that appeal, counsel, and I don't know if you have given value to it, is that appeal was made with leave. The trademarks appeal? Leave was obtained.
Yes, sir. Yes, sir. But that takes me to my second limb of my argument here. Even directly from the tribunal to the Court of Appeal, section 6.3.
Sorry. Repeat that. Repeat.
Even Your Honor, an appeal directly from the tribunal to the Court of Appeal is still divided into two
But with
categories.
respect, whatever says that they can do that, an appeal directly from the tribunal to the Court of Appeal?
Not this tribunal is speaking about, Mr. Punai.
The Rights Assessment
Your
Committee?
Honor, Your Honor, 62D refers to an order upon appeal from any other court, tribunal, body, or person.
Yeah. Sorry, I think what my brother, what my brother Justice Witt was indicating to you is that the opening words, the umbrella section of 6.2, says that an appeal shall lie to the Court of Appeal in any cause or matter from any order of the full court or a judge of the High Court. So it always has to come from the High Court. It always has to come from the High Court. And then it goes on to particularize the different instances where the qualifications are set out.
I take Your Honor's point in that regard. Your Honor, there is still our alternative submission that even if our appeal is caught by Section 6.2D, then by virtue of Section 6.3, our appeal is on a question of law. And therefore, by virtue of Section 6.3A1, it is an appeal as of right to the Court of Appeal, and not with leave in case of Section 6.3B of the Court of Appeal Act.
But you see, Counsel, the difficulty with that is premise that it is on a question of law. But 6.3 B says that in any case you need leave.
Well, Your Honor, the Court of Appeal has, in our submission, respectfully interpreted any case to mean any other case except the itemized cases in A1 and 2.
Well, that may be their view, but I want to offer you the other view, which is that the word other does not appear in the legislation, and it may be that the Court of Appeal, by reading other into it, simply inserted something which does not exist and which has no place. So the alternative view to what the Court of Appeal seems to have said is 6.3, no appeal shall lie from an order referred to in subsection 2D, which is an order made upon appeal from a tribunal. So no appeal shall lie, A, except 1 and 2, and B, in any case, except with the leave. So there are two criteria or two qualifications which 6.3 imposes. Except upon a question of law, or the things in 2, precluding any party from exercise of his profession, etc., and in any case, except with the leave of the full court. In any of those cases. So look at
Your
it.
Honor,
6.3a, no appeal shall lie except 1, upon a question of law. 2, where such order precludes any party from exercising his professional calling. 3, from holding of public office. 4, from membership of a public body. 5, from the right to vote at the election of a member for any such body. So there are 5 cases in which no appeal shall lie, except in those 5 cases. And in any of those 5 cases, you need leave.
Your Honor, with great respect, ma'am, I differ in the interpretation of the two categories. our submission is because the legislators itemized two categories, 63A and 63B. The first category is meant to, because of the importance raised in those matters, question of law.
Let me interrupt you, Counsel. There are not two categories itemized.
That's okay, sir.
There are not two categories. B is not a category.
63A1 and 2.
Right. So there are 5 categories in 63A. Yeah.
I'm talking about A.
Right. So there are 5 cases in
What I was referring to,
63A.
Your Honor, is 63A1 and 2.
Right.
One-
And I'm suggesting to you, if you would work with me there, there are 5 cases in 63A 1 and 2. There are 5 cases. Yeah?
I see that, Your Honor.
Yes. And therefore B says, in any case,
Yes, Your Honor, I see that.
you need leave. Think about the alternative, Counsel.
Our submission, sir, is that Your Honor, our submission is that in those 5 cases, an appeal exists as of right, and in any other case, as in 63B, leave of the full court or of the court of appeal is required.
You use
The rationale, respectfully, in respect of 63A1 and 2, which are the 5 cases.
Yeah, Counsel, you need to keep interjecting that word other, which is not there. Let me ask you a different question. Take 63B. In any case, except with the leave of the full court. On what basis would a judge give leave under 63B? In what case? Let me ask you in a more pointed way.
I cannot conceive of
What limitations would there be upon a judge giving leave?
Sure, it would be in any one of these cases. A particular case in which would be caught by Section 63B. I would suppose, Your Honor, any other case.
No.
those
Leave out the other. You
itemized
cannot get in
63B1.
that other. You need to get in that other, and you can't. Because other is not in the legislation.
Your Honor, the
Yeah.
concern that is has arisen here is why can the legislators choose to itemize and divide 6.3 into 2 categories? If they had one, then they should have just inserted 6.3B alone without itemizing 6.3A1 and 2. There must be a reason behind the intention to categorize 6.3 into 6.3A1 and 2 and 6.3B, Your Honor.
My colleagues are telling me that we have gotten your point. So let me not detain you any further except to answer your question. The reason why the legislature categorized those 5 cases is because they intended to limit the grant of leave to appeal to those 5 cases. You can get a grant of leave to appeal in no other case but in one of these 5 cases. But as I said, the view is that we fully understand what you're saying, and I hope you fully understand what I'm trying to suggest
Yes,
as an alternative.
certainly, sir.
Yeah, Mr.
Certainly.
Kunai, just going back to the whole issue of the stay of execution that you sought. Well, you have a stay from the RICE committee. You have a stay of the application for possession. And as
Yes,
I
ma'am.
am reading through here, section 30 of that act says that it appears that you can make an application for a stay under section 30, where you have an order, where an order for possession has been made under section 28. Am I reading it correctly?
This was second page, Your Honor.
So you're not dependent on any other court to give you a stay. You can start right there with the committee if an order for possession is made.
Your Honor, section 30, the stay or the suspension of the execution of the order is meant only to operate temporarily, as it says, to stay or postpone the date of possession for such period as the king's fit, and from time to time grant further stays or suspensions of execution and further postponements of the date of the possession. It's not meant to operate permanently, please, Your Honor.
Sorry, I'm not hearing you.
It's not meant to operate permanently as a permanent stay of the order of the
No, I do understand that. I don't think that
I don't
you
think
would
any-
want
I don't think any
a
state-
permanent stay of an order for possession. But tell me something, Mr. Kunai, you would admit though that this is an avenue open to you. But you are not even in that unfortunate position. You have gotten them to stay the application for possession against you.
Pending the outcome of the application before Your Honor.
Can I ask this question, Mr. Punai? Is it likely that the Rice Board the committee would pursue the application for possession if the matter were in the Court of Appeal?
Your Honor, if no stay of execution is granted, whether by this honorable court or the Court of Appeal, the Rice Assessment Committee will proceed to hear the application for possession.
That is something that you have raised with them, Mr. Punai?
That is something that both Mr. Satram has insisted on, and the committee has held its hand until Your Honors make a determination on the application for special.
Yeah, but I don't think that even that determination, whatever it will be, necessarily decides the case in its finality. So I think as long as there is an appeal pending, everybody would be wise to stay calm and don't make a move. Now, coming back to the interpretation of Section 6 of the Court of Appeal Act. So it is clear the position that Justice Barrow just set out is a clear one. But the Court of Appeal, in this case, Justice Persaud, gave another interpretation, saying apparently 1A and 1A1 and 2 would be an appeal as of right, as I understand it, while any other appeal would be with leave. And but he said, well, that would then be upon a question of law, and in my view, this is not a question of law. It's an application of procedural rules. That is his opinion. Now, the idea that A1 and 2 would be appeal as of right, while the others would be simply with leave of the full court or the Court of Appeal itself. That is the opinion expressed by the Justice of Appeal in this case. Is that the practice of the Court of Appeal? Is this how they look at this provision normally? Are there more cases where it is shown that that is their interpretation? Is that, can you answer that?
Your Honor, interestingly enough, there is a dearth of authority on the interpretation of 6.2d and 6.3 of the Court of Appeal Act. Our search has revealed we have not come up with anything which touches on concern that is sort of interpretation, please, Your Honor.
Now suppose,
I'm not sure if Mr. Satram has authorities that he has unearthed in relation to that interpretation.
okay, now suppose that this would have been, this is an appeal which is possible, but only with leave of the Court of Appeal. You didn't apply for leave to appeal. Suppose the appeal will come back before the Court of Appeal. Would it still be possible to apply for leave?
Your Honor, if this court is of the view that leave was required, I may have to proceed with an application to the Court of Appeal for leave to appeal.
Well, you can, you never know, so it's always safe to have something at hand if it needs to be addressed in that way. But I'm not sure if we are going to give it a final determination on that at this point in time. Okay, so I think your position is clear. Is there anything else that you want to add at this point in time?
Yes, Your Honor. On our second ground that we wish to advance, and as set out in our affidavit, our respective affidavits, we have been dealt an unfair hand by the committee. The full court did not consider our appeal on its merits.
No, we know that.
We believe that.
No, we know that. And we have seen how they reacted, and we have our thoughts about that, but we don't have to really go there at this in this instance. So we were just focusing on this particular point, which we now have discussed, I think, fully. Okay, Mr.
In that regard, I have no further submissions in that regard, please.
Okay, thank you very much.
Thank you, sir.
Mr. Satram.
Yes, please, Your Honor. Your Honor, the question is whether the applicant needed, as identified by this court, is whether the applicant needed leave to appeal from the full court to the Court of Appeal. And the answer to that lies in the proper reading of subsection 6.3 of the Court of Appeal Act. Now, 6.3 circumscribes or limits the right of appeal conferred by 6.2d. And in our submission, it does so in two ways. Section 6.3a limits the scope of the appeal. It says what questions or issues may be pursued on appeal. And section 6.3b creates a precondition of appeal. In other words, it says it imposes a requirement of leave to appeal. Now, contrary to the way the Court of Appeal looked at the provision, 6.3a does not create an as of right category of appeals or as an as of right pathway to the Court of Appeal. And likewise, 6.3b does not create a discretionary pathway to the Court of Appeal. The phrase in any case does not mean in any other case. The promulgators of the law knew and used the phrase in any other in section 6.2d itself. If your honors look at 6.2d, you will see that the draftsman used the phrase any other. So, and 6.2d is referenced in 6.3. So, in our submission, in any other was deliberately avoided. The use of it was deliberately avoided by the draftsman. And he must be taken to know the difference between in any case and in any other case, because he used both in the same section. Now, in any case in our submission means in all cases. And in any other case means cases or situations in addition to those already identified. Now, if that is what the promulgators of the law used, and that is what they intended. Now, 6.3 is a restrictive provision, and in our submission, it must be construed restrictively. And there's a policy behind this restriction or limitation, Your Honor, created by Section 6.3. These specialist tribunals were set up to relieve the judiciary of certain problems. And that purpose in our submission would be undermined or defeated if a litigant had unrestricted access to the appeals process. Now, there is an appeal as of right on both questions of law and fact from the Rights Assessment Committee to the full court. And that is conferred by Section 26(5) of the Rights, Farm and Security of Tenure Act. But beyond that, any further appeal to the Court of Appeal lies with leave, and in the case of the Rights Assessment Committee, is limited to questions of law. Now, on the point of the stay of execution, which Your Honor have raised early in the arguments, what the applicants ultimately want from this court is an interlocutory order, a stay of execution of the decision of the committee granting leave to issue a notice to quit. Your Honors will see the summons which was filed in this case before the single judge of the Court of Appeal at page 41 of the record. That's in appeal number 005. You will see there that there is a prayer stay of execution of the decision of the committee dated the 29th of September 2017 until the hearing and determination of the appeal. That is what they have asked for, and that is what they ultimately want from this court. Now, notice has already been issued. That notice to quit has already been issued. And we would submit that a stay of that decision, the decision of the 29th of September, because it has already happened. The second point, Your Honor, which Your Honors have raised, is that there can be no stay of execution of the order of the committee that can be granted by a single judge of the Court of Appeal.
No leave problem.
Order 2, Rule 16C, which Your Honors have dealt with recent Sahoy case, says that the stay of execution may be granted on any judgment appealed from. The judgment appealed from was the full court decision, and the single judge of the Court of Appeal had no jurisdiction to grant a stay of the decision of the committee. Likewise, the appeal to Your Honors is from a decision of the Court of Appeal, and that decision was to simply dismiss the motion. The dismissal of the motion is not a decision which can be stayed. It is spent from the time it is pronounced. Now, Your Honor, the Court of Appeal was asked to make orders in an appeal which was not properly before it. It had to decide, in our view, whether they could make orders in the appeal, whether it's stay or whatever. And the pronouncements on the issue of whether leave was required or not is binding on us, the parties to the appeal. Now, both parties, I believe, agreed to be bound by a determination as to whether the appeal was properly filed. And there's no sense, Your Honor, in leaving that issue open or sending it back to be determined in the appeal itself. When Your Honors look at page 2 of the record, that is in the application for special leave to appeal, you will see in paragraph C that the applicants are asking this court to say whether leave was necessary or not. That is one of the reliefs they have sought before Your Honor. It says under the inherent powers of the court that the court do pronounce on whether the appeal filed was properly filed without the requirement for leave to appeal. So my submission, Your Honor, our submission is that they are asking Your Honors to decide, notwithstanding that the Court of Appeal did not make orders in the appeal itself on whether leave was necessary. They are asking this court to decide whether the appeal was properly filed without leave. And the Court of Appeal has made a pronouncement, although we do not agree with its reasoning. It has made a pronouncement that the appeal should have been filed with leave. And in those circumstances, Your Honors can say whether the appeal should be filed with or without leave and put an end to the matter. The Court of Appeal is already of the view that leave was necessary. There's no sense sending it back if Your Honor share that view. If Your Honor share that view. There's no sense sending it back to the Court of Appeal to revisit that issue when all of us are saying we agree to be bound by a pronouncement on the matter by this court.
Okay. That's it?
Yes, Your Honor, unless there are any questions.
No, you have been very clear. So just to be clear, you do not agree with the reasoning of the Court of Appeal on this particular point. They're saying, okay, well, you have an appeal as of right under A1 and 2, and in all other cases, you have an appeal with leave of the full court or with our leave. Is this a question of law? They say, no, it's not a question of law. Mr. Puna is saying, well, yes, I agree with that idea that you have an appeal as of right under A and an appeal with leave from the full court of the Court of Appeal under B, but this is a question of law, about the question of law. Your position is, I think as captured by Justice Barrow, only in the cases A1 and A2 can you have an appeal, but it is always with leave from the full court or the Court of Appeal. Is that
Yes.
that is correct?
Yes, please.
Okay, and you're saying, well, okay, although the Court of Appeal has not decided the appeal itself or this issue in the appeal itself, they have decided it in this particular matter. So please, CJ, give your views within this matter on this particular point. And
Yes.
so in fact, you are saying, give them leave to deal with it. because this is about special leave. Are we going to give special leave or not? You are actually saying, yeah, give them special leave so that you can pronounce on this point. Is that correct?
Well, I'm not exactly saying that, but if it disposes of matter finally.
You're not using those words, but isn't that what it comes down to?
Mr. Satram, I get the impression that yours is a more more refined and cautionary approach, which is, if you, the CCJ, are going to decide that they needed special leave, then by all means decide the whole thing now.
Well, you see, Your Honor, if it's special leave...
Sorry, not special leave, that they needed leave at the Court of Appeal.
Yes,
Yes.
yes.
So
Your Honors can make that pronouncement
while
without granting special-
refusing special leave?
Your Honors can make such a pronouncement without granting special leave, because in a set merits of the appeal, Your Honor can make such a pronouncement. Because, you see, at a policy level, Your Honors have to decide whether, as a general rule, you'll grant special leave to appeal to deal with what are essentially procedural issues and interlocutory issues. This is not a case of general importance, of public importance. And if it is bound to fail, then there is no sense in granting special leave. But that does not prevent you from making a pronouncement on whether leave was necessary or not, which can guide us all.
Okay, well,
I think we understand, Mr.
yeah, we fully understand. Reply, Mr. Puna? I think the positions are clear, but...
Yes, Your Honor, I would decline replying.
Okay. Okay, well,
Sorry, Mr. Punai, you also think we should decide the question whether leave was needed?
Yes, certainly, sir.
yeah.
All right, thanks.
Okay, well, we will discuss this for a while. So I think we adjourn for 5 minutes and then we will be back and see how to proceed.
Thanks.
Please take your seats.
Okay, gentlemen, I think we're able to make up our mind. We can give a decision, which is that we will dismiss the application for special leave. We will go into the underlying issues that are relevant, the ones that were discussed today. We will give our reasons in writing within a few weeks' time. So you can expect them within a very reasonable time in writing. Then costs. Is there anything to be said on that?
Your Honor, we had proposed basic costs for each of the respondents because they're separate respondents.
Basic costs? What?
For each of the respondents,
For each
the
of-
basic costs 4 or 5 times, yes.
The arguments are the same.
So let's hear from Mr. Punai on that.
Brothers, we had indicated in our random to the court on the issue of cost that 300,000 Guyana dollars in total, $75,000 each for each one of the applications, please, Your Honor.
The basic costs are what, $5,000?
189,000 or thereabouts.
Okay. Okay, well, we think it would be unfair to multiply the amount of the basic cost. In this case, it would be 89,750 Guyanese dollars. We will make that 100,000 for all 4. So together they are to pay the respondents 100,000 Guyanese dollars.
Thank you, sir.
Not each. Thank you.
Not each, no. Okay,
That's it.
all rise.